Hello. I now call. I'm sorry. Okay, I'll repeat it. I now call the December 10, 2025 Building Standards Commission meeting to order. Public comment. Citizens are permitted to address the building. Should I use this? All right, let's see if this stays. Citizens are permitted to address the Building Standards Commission with regard to matter posted for consideration on the agenda. Each speaker must complete a request to speak form and give it to the city secretary. Each speaker is limited to 3 minutes. Speakers requiring a translator will have 6 minutes, regardless of the number of agenda items to be addressed. Comments or discussion by the Building Standards Commission will only be made at the time the subject is scheduled for consideration. At this time, I will open the public comment. Do we have any?
No, Chair, we do not.
This time, we will close the public comments. Consideration of and action on approval of minutes of City of Sugar Land Building Standards Commission meeting on November 12, 2025. Does anybody have any corrections? Lena, Mumtaz, anybody? No. Do I hear motion to approve the minutes? Please state your name to motion. Press.
I'll second it.
State your name.
Lusky.
Mal Lusky. Any discussion? Vote at this time by raising your hand if you agree. Ayes unanimous. Minutes approved. Review of and discussion on purpose, roles, responsibilities, and functions of the Building Standards Commission. Joshua Doyle, Chief Building Official. Nicole Guevara, Assistant Director of Neighborhood Services. Stephen Lammers, Building Inspector 3, and Meredith Reed, City Attorney. Staff will now make presentation, and this is not an action item, so go on. There will be no motion. Learn what we're supposed to do.
Good evening, Commissioners. Tonight we're going to go over annual orientation and ethics training. As has been tradition over the last few years, we allow an opportunity for our annual orientation for our other team members to give an opportunity to present to the Commission. So tonight we have Stephen Lammers, one of our Building Inspector 3s.
Building Inspector of the City of as agenda. For City Council Board and Commission policy and procedures, staff liaisons will hold an annual orientation workshop as part of a meeting of the as introductions of a member, staff, authorities, policies, and materials, topics relevant to the work of the Commission, legal considerations, open meetings, conflicts of interest, and meeting procedures. We have 2 new members, Sam Morris, alternate, and Jitesh Chichani, alternate. Commission overview. Commission authority comes from state law, Chapter 54, local government codes, and City of Sugar Land Codes of Ordinances, Chapter 2, Article 3, Section 253. Commission overview. Commission is a quasi-judicial body that hears evidence and receives testimony, issues orders similar in nature to a court. Decisions only appeal to state district court, so no appeals to City Council. Zoning Board of Adjustments is city's only other quasi-judicial body. Hello? Okay. Commission members are appointed by City Council, 2-year staggered term. There's 7 members on the board with 3 alternates. Should have experience training in building construction or property maintenance. The City Council appoints chairs and vice chairs annually. The commission is a quorum in voting. Majority of commission would be 4, which constitutes a quorum. Members present required to vote on each item unless have a conflict of interest. Attendance. Each member or commission member is expected to attend most meetings. Absence should be reported to staff liaison prior to hearing a date. Members missing 3 consecutive meetings is deemed to have automatically resigned. Alternates will serve in the absence of regular members and on rotating basis. Conflicts. Members must abstain from discussing, voting on a matter before the commission when the member or alternate has a conflict of interest under state law or city ordinance, believes that he or she cannot render a fair and impartial decision in the matter due to personal circumstances. Members or alternates with a conflict of interest must inform the city secretary of the conflict prior to the start of the meeting and file a conflict of interest affidavit. The commission duties are to adjudicate unsafe structure cases arising under dangerous buildings regulations, hear and decide appeals of the determinations made by the city staff in the application or enforcement of building codes, hear appeals regarding the denial or revocation of residential rental license, authorize variances from the terms of any building code adopted by the city. Dangerous buildings. The commission's authority and duties outlined in Dangerous Buildings Ordinance, Chapter 3, Article 12 of the Code of Ordinances. Section 191, all dangerous buildings are declared to be public nuisances and must be vacated, secured, repaired, or demolished. Section 193 provides standards for when a property is to be ordered repaired if greater than 50% of the structure must be repaired or value reduced by greater than 50% because of violations, vacated and secured. Conditions make it hazardous to health, safety, general welfare of occupants or publics, or demolished when greater than 50% of the building is damaged, decayed, or deteriorated, and building cannot be repaired. Section 194, minimum standards for continued use of occupancy of a building are in the 2021 International Property Maintenance Code. Building is deemed dangerous if a wall or other vertical member lists, leans, or buckles to an extent that a plumb line passes through the center or gravity falls outside the middle third of the base. Exclusive foundation, greater than 33% damage or deterioration to structural components or 50% damage to non-structural components. And properly distributed load under floor or roof, overload roof or floor or roof with insufficient strength to be reasonably safe or purpose used. Damage by fire, wind, or other causes so as to be dangerous to life, safety, morals, health, or welfare of the occupants or public. Dilapidation or decay or unsafe or unsanitary conditions, inadequate life, air, sanitation facilities to protect health, safety, or general welfare of human occupying the premises. Inadequate facilities for egress in case of fire or panic, or insufficient stairways, elevators, or fire escapes. 2 or more code violations or single violation posing imminent threat to life or property, or unsecure from unauthorized entry and utilized by vagrants or children. Buildings boarded up, fenced, or secured by the buildings boarded up, fenced, or secured may be deemed dangerous buildings if the building constitutes a danger to public even though secured from entry, or means utilized to secure the building is not adequate to prevent unauthorized entry to the building. So here are a few examples of an unsafe structure or dilapidated. As you can see, these structures are dilapidated, right? So they basically deemed that, was this brought to the board? Okay. Here are some unsafe structures from fire damage. As you can see, the fire damage to the framing members in the center and the wall on the right are completely gone, and the one on the left is boarded up, which meets that one definition. And then this is examples of an unsafe structure due to unsanitary conditions and illegal construction. The picture on the left and middle are due to unsanitary conditions, which pose health hazards, and then the one on the right is an example of illegal work. Building code appeals and variances. Owner may appeal a decision or determinations made by the building official or any of the following. Building official rejected or refused to approve manner of construction or materials to be used in installation or alteration of a building, structure, or service system. Provisions of code do not apply to these cases. Provisions of code do not apply to the case. Equally good or better form of construction is proposed. True intent and meaning of code has been misconstrued or incorrectly interpreted. Consideration of variance is justified when enforcement of building codes create unjust or is contrary to spirit of purpose of code's technical requirements or best interests of the public.
Good evening, Commissioners. So the next part of what falls within your purview is in regards to residential rental licensing program. So we do here in the city require that all rental properties be licensed and inspected every year. We do interior inspections during the change of occupancy when it's requested by the tenant, or if there's a problem on the outside that indicates that there's a very real problem inside. We've seen, large holes in the roof, noticed severe dilapidation through windows. So those are all signs that there's a serious problem inside. Now, we may either refuse to issue that license when it comes up for renewal, or we could revoke it. So one of the things that would fall within your purview is determining whether if the owner were to appeal that revocation or denial, whether that was valid. So we would hold a hearing within 20 business days after an appeal has been filed with us. So some examples of reasons why we would deny a license would be electrical issues or swimming pool enclosures. So there's, if it's a life safety issue, it's something that can result in a denial or a revocation. So really today what we want to talk to y'all about is just a broad training for this commission. I know we don't meet very often except for these clusters. It's either feast or famine, where we're meeting every month for, half a year, and then we don't see you again but once a year for your orientation for a few years. So you are required to have an annual orientation. You are required to have training on the Open Meetings Act, and then ethics training through our city attorney's office. So we also have an opportunity, if we need to get legal advice from the city attorney. As you know, we always have someone from our legal department here at these meetings. So if there's something that comes up during an actual hearing where we're discussing a case, there is an opportunity to call for an executive session. And that is privileged discussion that occurs away from the public, and it's documented via certified agenda. Okay, so the hearing for a case. We as staff start an investigation. So we gather evidence, what's going on, reach out to the property owner, find out if there's any lien holders, that sort of thing. We issue a notice letting them know that as staff, we've determined it's necessary to come to you as the board. And then we have a hearing where staff will present evidence to you, the owner will present evidence to you, the lien holders will present evidence to you, and you'll make a decision based on that discussion and issue a final order. That order is filed both with the county, and we also print it in the newspaper, and obviously we send it certified mail to to all the owners, lien holders, or mortgagees. So our board meetings do typically start at 5:30. So we ask that you all plan to arrive by about 5:20, just so that you can get seated and logged in. We are in the process of changing some software, so eventually you'll be able to log in at your, at your seat and be able to vote that way. We're not quite there yet. So that's why we're taking the hand votes right now. If you're running late, we do ask that you let us know, just so that we know whether or not we can go ahead and start, or if we need to delay the meeting, because these are public meetings, so we can't start any earlier. We can start a little bit later, but we can't start any earlier. So we just want to know kind of what your time frame is for arriving. Now, I have provided everyone with some training materials. So if you look at the scripts that we typically provide during a hearing, you'll see that the first thing that happens is the chair will call the meeting to order. And then we have a public comment period. Now at this time, speakers can address any topic on the agenda, but when they come up, they'll state their first name. Now, just to keep in mind, this isn't a time for any kind of discussion or debate. This is public comment. This is a listening only time frame. So if you look at the agenda, the first thing is public comment. Okay, and then you have your minutes. So our chair, whoever that is, will read the item caption, and commissioners should be reviewing these minutes ahead of the meeting so that you can document any necessary corrections. Okay, now what could that look like, hypothetically? Let's say, you remember that maybe you're the one that that seconded a motion, but the minutes may say someone else. That's an example of a correction that you could bring up during this time frame. So if you identify corrections, make sure you raise your hand so that you can be identified by the chair, and then provide that correction. Okay, so the minutes is the first time in a meeting that the commissioner will make a motion. So someone will say, make a motion. You'll state your name, and that way we have that for the record. And so again, anyone who's making a motion, just remember to state your name. So you raise your hand, you'll get called on by the chair, state your name. Okay, so once there's a motion and a second, it's time to vote. So the chair will ask for a hand vote or a computer vote, and you'll just make sure you keep your hands up until you're instructed that you can put them down, because we're taking notes on how everyone is voting. Okay, and at that point, the chair will kind of restate those results. The motion passes, unanimous, or it passes, 2-3 or something like that, Okay, and then we move on to our cases. So each case being heard has a public hearing. So the chair will call the item and will swear in any speakers. So I don't know how many of you recall during the last meeting. Everyone who's going to be speaking on a case at the beginning has to raise their right hand and agree to tell the truth under penalty of perjury. Okay, so that will happen every time there is a case that we're hearing. So once everyone is sworn in, the chair will open the public hearing and instruct staff to proceed with the presentation. Once we complete that presentation, the chair will call the property owner or lien holder or mortgagee. So at this point, you'll see the slide switch over to property owner, lien holder, or mortgagee. So that'll be the title of that slide. So anyone who speaks, again, has to have been sworn in, and they should have also filled out some speaker forms so that city secretary has their contact information. So next will be any members of the public who have an interest in the case, but may not be the owner, mortgagee, or lien holder. So we've seen this a lot recently, where we'll have HOA representatives or neighbors or heirs. So this is a time frame for them to speak. So again, everyone just has to have been sworn in so that they can speak. Now, one thing to keep in mind is that discussion and questions should really be limited directly to the case itself. So only evidence or testimony provided during the staff presentation or during the public hearing may be taken into consideration. I know you may be curious about a case coming up. You do get the address beforehand, but just know that if you drive by and you see something, you cannot bring that up, because that is not something that is being presented here by staff or by another member of the public. So, you know, just keep that in mind. And it's definitely not something that you can talk about with the other commissioners before or during the case itself. So you really need to focus on the property conditions itself, the requirements for compliance, and the owner's proposed compliance schedule. So we ask that you refrain from any questions related to the personal finances, their plans for a property not related to the current order. So a good example of that is, you know, let's say someone is proposing to repair a house, repair the structure. You can ask questions like, do you have the finances necessary to complete this proposed repair? What you can't ask is, how much money do you have in the bank? Those are two different questions, you know. Have you looked for financing to make a repair? What bank do you use? You know, those are two separate questions. Understand how both may come up, but some are relevant to the case at hand and others are not. So just be cautious about that. Okay, it's also incredibly important to have all discussions during the public hearing itself. Okay, so last time there was a lot of standing up and coming down, and we heard commentary from members of the public, but just keeping in mind that folks have the opportunity to come up to the podium. That's their chance to say their piece. Otherwise, once they sit down and we close the public hearing, folks can no longer come up. Okay, so the commissioner should ask, once everyone is seated, the commissioner should ask, are there any other speakers on this item? Hearing none, we'll close the public hearing and move on to deliberation. So again, once that public hearing is closed, commentary is limited to specific questions from the commission. You know, so that's something that we haven't been, you know, we've struggled with that a bit in the past where folks have kind of popped up. So we just need to make sure that if there are questions from the commission, you need to very clearly articulate those questions so that someone can come up and specifically answer that. Okay, so on to all of the paperwork that I gave you. So each commissioner will have, moving forward, a blank order. So if you want to look at your blank order. At your blank order? Okay. So the chair will first ask the question. The commission finds the structure is safe or unsafe, right? So based on the testimony, based on the deliberation, you'll have to check one of those boxes. And then the chair will read through every item and obtain consensus on whether or not the property qualifies for those conditions. So that's the 1 through 9. And as you recall, those are all of the elements that qualify as a dangerous building. So it can be 1, it can be all, it can be half. It depends on the case. Now, staff, when we're giving our presentation, we'll try and summarize close to the end of the presentation what we recommend. And so if there's ever a question about an element, we do ask, feel free to toss out any questions that you may have for staff on why we chose to recommend certain elements and why we felt others did not qualify. Okay. Sorry, I got a little bit ahead of myself. So near the bottom of this page, there are also some additional elements that we'll need the commission to take a look at. So whether it's occupied and poses a health, safety, or general welfare hazard, if it's unsecured, if it may be feasibly repaired, if it may not be feasibly repaired. So again, just when you're having your deliberation, this is why there's so much back and forth and a lot of discussion, because there's a lot of different kind of questions to answer. So the chair will formally check one as necessary. Okay, and then we'll go to the next page. And I think this is where most of our kind of back and forth discussion comes from, is the parameters of the order itself. So we really need the board to focus on specific deadlines. So securing a property, repairs, submittal, construction plans. It's not feasible for it to be kind of a moving target. So a good example is during the last meeting, initially, there was a conversation about 30 days from the date of closing, but the date of closing may move. It may not happen at all. So we're really looking for hard deadlines, 30 days, also, December 12th, 2025. Now, if you look at the form, it talks about a time frame to vacate the structure, secure the structure, demolish, repair, or remove the structure, and you have to circle 1. And historically, we've also implemented other requirements like weekly meetings with city staff, or things like that. So this is where all of that, the particulars of an order, will be included. And then just as a reminder, we do make recommendations based on reasonable abatement timeframes, based on the information that we receive the Monday before a meeting. But as we've seen here in the last few months, things change very quickly, and sometimes we get some, day of information for y'all to consider. So again, it's just highly encouraged that commissioners ask staff about the impacts of some of that impromptu information. So any orders to demolish will always be at least 30 days to allow sufficient time for an appeal and to reduce the liability for a takings lawsuit. As a city, we never want to get sued for allegedly taking a property. So we want to take every precaution possible to avoid that, which includes the 30-day time frame. So just keep that in mind. And then again, if the commission is in need of legal guidance, the chair can request to adjourn for a closed executive session, which will be documented by the city secretary. Now, once y'all have come to a general consensus on what the order requirements are, the chair will go through this form again and read off all of it, okay? Just to make sure everyone is on the same page and aware of what the current proposed order is. If there are any questions or a commissioner would like to recommend a modification, this is the time to make those changes, right? So. Sure. Turn on, if you can turn on your mic, and then bring your mic down for you. Sure.
These elements that qualify, these 9 elements,
Yes.
the chair will have to go through each element.
Yes.
Right? And then, before he makes his yes or no, you'll have to take a vote, right?
So not a vote in the same sense as like a hand vote.
Yeah,
But if you recall from previous meetings, the chair will say, do we think one or more walls or other vertical structural members list lean or buckle to such an
So if
extent?
there-
And then folks will say, yeah, or no, and then it'll
So if
either be a
there are-
check or an X.
So if there are, let's say, 4 and 4, so what the chair does then?
That's a good question.
I mean, I'm just
Yeah,
saying.
it will not be 4 and 4 because you would not have your alternate sitting up here. You would just have a full panel of 5.
So 7, okay.
It'll always be an odd
So
number.
you will take the majority, right?
Yes, sir.
So that means you will have to count the votes, sort of, in your head or anything.
Yes, sir.
Yeah,
No, not in the head. It will be, it's public hearing.
yeah, public
So we'll be
hearing.
counting the vote on the microphone.
Will y'all turn on your,
Yeah, we'll be counting the vote. Lena said yes, Mumtaz said no, Ravi said no. And so
So-
we pass it by 4 to 3.
Okay, so
Or
in-
2 to 5. I
In
mean,
the
2 to 1.
end, there are 9 elements, let's say the Ben. So how do you decide about the whole thing, 4 or 5, or let's say, what happens, like if 4 yes and 5 no's, or 5 no's and 4 yes? So you still go for majority? Is that how you do?
Yeah, yeah.
That's what it is?
So on each element, Nicole, correct me if I'm wrong, each element will have a yes or no.
yes,
Yes,
Okay, and the conclusion, the
Yes.
chair will say, so we agreed on the structure has improperly distributed load upon the floor or roof. The chair will not go through all 9, only go through those agreed as making it unsafe,
yes,
right?
yes.
That's a conclusion because we are now collecting to say we agree this is unsafe because 1, 2, 8, and 9.
and you can leave out few?
Yeah, yeah.
Yes. Because you don't have to meet every one of the 9 elements to be considered a dangerous building.
Correct.
So you can just skip?
You can say, no, that's not applicable.
Well, you'll still
Like we
read.
did.
Yeah. The chair will still run through all of them, but it'll be
Just say,
yes or no.
yeah, okay, thank you very much.
Okay. Sorry, I lost my train of thought. Where was I? Okay. And then another thing to make note of is at the bottom, there's a compliance hearing date. So again, there's a lot of information on this order that we need to run through and fill out. And that's why at the end of the meeting, there's so much back and forth discussion. But that's why, because we have to fill out this entire order. Okay. And then, again, we provide compliance timeframes for all of the necessary repairs or actions. And then this document is, at the end of the night, signed by the chair. And we send copies of this, which is why, again, it's so important to have all of the, it's either an X or it's a check or, all of the information filled out in a way that's easily understood, because we provide a copy of this to the owner, mortgagee, and lien holder, and then we file it with the county.
And if all the members have this.
The only one that will get filed is the
Yes.
chair's.
So even if I write it here, I
You can write it.
throw it away.
That is for your reference.
Yeah, yeah. I thought I have to submit it to
No. It's just the official document that is signed by
chair.
the chair.
Yeah, that's what it is.
Okay. Okay, so once all of the cases have been heard, the chair will ask for a motion to adjourn. And again, we'll get a first and a second, and you will state your name out loud. As you can see, one thing I forgot in here, all of the mics are kind of pointed up. So just make sure that before you start speaking, that you bring it down to yourself and you make sure that it's on. These meetings are public. So we want to make sure that anyone who's watching can hear what all is being said. So just double check that. So that is the run through of the order and some sample scripts. We did want to bring up some interesting bits of information. So we're currently operating under the 21 ICC codes, International Code Council. Those are our building codes. So we're presenting the 24 ICC codes for adoption actually next Tuesday during a city council meeting. So we'll be adopting a new set of building codes here in the next few weeks. And then we just completed the 89th state legislature. There were several bills that were filed, unfortunately, that target regulatory power of local jurisdictions. So moving forward, we're kind of sorting through all of those changes, but currently there are no permit requirements for solar installations or residential backup generator installations. So it's quite an interesting time for us here in Texas, but we're figuring it out. And then we just wanted to introduce all of our team. So this is everyone that you could potentially hear from. I do want to point out Eleanor Hibbs. She is the individual who emails y'all. Okay, so just make sure that you're getting her emails and it's not going to your spam. She does send out an appointment for our meetings, and as long as it's on your calendar, we're still having it. So just keep that in mind. And if you have any questions, feel free to reach out to us. Sure.
You were saying that the ICC codes 2024 will be passed in the next council meeting?
Yes.
Will they
So it'll go for first reading.
Okay.
We have to have first reading, and then we have second reading in January 2nd. January 2nd will be second reading.
Okay, once they're passed, will they be made public?
Yes. Actually, there's already a website for it, so you can already, take a gander at some of the information and make comments on it and send us emails or ask us questions if you like. But yeah.
Okay, thank you.
Any other questions for us before I kick it over to Meredith for your ethics training? Anything else? All right, thank you very much.
Can you go?
May I just say something really quickly? I'm sorry. I just want to thank y'all. You do such great work, and you make it easy for us. So, thank y'all.
Good evening. My name is Meredith Reedy. I am your city attorney. As you saw on the last slide, usually Tricia Dang is going to be here to watch you and make sure that you stay on track. But she decided to send me this evening, so you're going to have to do ethics training with me. For those of you who have done it in the past, congratulations, you get to do it again. The ethics training has not changed. This is the same game we played last year. If you have the privilege of playing next year, it will change. If you know the answers, please shout it out, because this is participatory. If it looks like you're sleeping, you don't get points, and you get to listen to it all over again. And I promise the second and third time is even longer than the first time. So with that in mind, welcome to the game of ethics. We have 3 objectives we're going to go over tonight. You're going to get your overview. You're going to get the training that you're required by code, and fingers crossed, you serve your term with no ethics violations. So who gets to play this little game? We invite all members of City Council. We invite members such as yourself of administrative advisory boards, and every once in a while we'll invite former council members, former other board members, and candidates for council to play along. As we go through these, I will try to point out which ones only apply to City Council and which ones apply to all boards, because I don't know what your future political aspirations might be. If you want to run for a different board or council, I'm going to go ahead and give you that information. Additionally, as a member of one of our boards, you have the obligation and responsibility, and as a resident, if you see something, say something. So I want to make sure you understand the rules and regulations so that you can be a fully informed resident as well as a board member. So there's 8 simple rules. And not all of these apply to you. As I'm sure you know, 7 and 8 only apply to city council, but congratulations, you will get to learn about them. So we're gonna go through all 8 of these rules this evening. So your first rule, and I forgot, Stephen? Stephen touched on conflicts of interest just a few minutes ago when he did his presentation. So state law requires you to disclose if you have a special economic benefit in an item on the agenda before you. Since you are a Building Standards Commission, the item is going to be a structure. How do you know if you have a special economic benefit in the structure? You own $2.5 thousand or more of the fair market value of that structure in front of you. Or if it's owned by a business, it's the rule of 10% or 15,000. If you own 10% of the fair market value of that entity, or $15,000 of your paycheck came from that entity last year, and you're saying, I believe I have a special economic benefit. What should I do? We're going to have you file a conflicts disclosure statement with the city clerk's office. We're going to ask that you abstain and go ahead and leave the room. We don't want there to be any confusion that you might be over here texting another board member or throwing signs like you're on a baseball team that may lead to confusion or belief that you unduly influenced one of your fellow board members. So you also get to tell us who you're related to. So if you are related to somebody who has an item before you're on the agenda this evening, we're going to tell you you have a conflict of interest and you're going to have to step out, abstain, and take a walk down the hall. Also, if you were to run for city council and there's an action item for a contract on the city council agenda, you get to tell us about the vendor if they're related to you. And that would be somebody within the first 3 degrees of consanguinity or 2nd degree by affinity. A beautiful chart sitting on my desk if you want to know exactly who those people are, but just basically keep in mind you, your spouse, your children, your parents, and go ahead and include your grandchildren and your siblings just in case. And so how do you know you need to tell us about your sibling, your parent, or whatever interest in a vendor? If they receive $2,500 or more from that vendor in the past year, and it's a rolling 12 months. It's a very low standard, but this is state law, not Meredith's law, so I'm going to ask that you keep that in mind. So this is the holiday time of year. We had Thanksgiving, people were giving away turkeys. Sometimes you get other gifts as well. Sometimes they're called gifts, that's what I call them. The district attorney's office calls them bribes. Call them what you like, you still get to brag to us about them. There's a form that you fill out and file with Linda's office, the city clerk's office. You get to brag to us when you receive gifts of lodging, transportation, entertainment, or food. And this is $100 cumulative value per individual vendor, and once again, it's a rolling 12 months. Now, it's not likely that somebody's going to come try to bribe you since you are on the Building Standards Commission and you're not as flashy and exciting as City Council or Planning and Zoning. However, you do have an opportunity to receive one of these gifts, and we look forward to finding out if you are the first board and commission member from BSC to actually receive one. You'll notice I put a little asterisk next to food. That's because if you have the privilege of sitting close enough to that vendor where you can have a conversation and actually have to listen to them while enjoying your meal, you can spend up to $500. So get an appetizer, get an extra dessert, and a doggy bag if you like, because you are now up to $500 for the privilege of having to entertain them during dinner. So we got 5 other rules just to go over. These are basically, number 1 is for city council. Doing business, well, actually this is all of you, doing business with the city. You are prohibited from entering into a contract with the city while serving on your board for the duration of your term. So if you're serving a 1-year term, divide that. If you're serving a life sentence, good luck. Basically, you cannot enter into any contract of a substantial business amount. And because this is city government, we consider a substantial business amount to be $1,000. Cumulative total. So please don't do that. Representations and appearances. If you know me, you know how much I love my hats. I come to different training sessions wearing hats, taking them on, taking them off. Basically, this is that you need to remember what hat you're wearing when you're doing things. So if you decide you want to post on Nextdoor, Facebook, any type of social media, or even write a letter to the editor, if editors still take those, we're going to ask that you go ahead and say, hi, I'm writing this in my capacity as a resident. So if Ms. Goldberg says, you know what, that city council is just off the wall, signed, Ms. Goldberg, resident of the city of Sugar Land. Or if for some reason you decide you want to wear a different hat, you can say, Ms. Goldberg, voting on this BSC item at this last meeting, this guy's a real loser. I can't believe he has roaches and rats. Sign, Ms. Goldberg, BSC member. But I know you're not going to do that. That's why I picked on you. Appearances. Additionally, for 2 years after you're serving your sentence here with, your term here with us, after serving your term, we ask that you don't come back in front of this board to represent somebody and get paid to do it. You have a 2-year ban. Unless it's your own personal property, you cannot come before your own board for 2 years. Misuse and disclosure of official information. Nicole talked to you about the privilege of going into executive session with me or somebody from my staff where we tell you top secret litigation type information or answer any legal questions you have related to an item on your agenda. We're going to say that because we're in that back room and because the door is shut and because state law requires it, that you don't take any of that information out and tell somebody who was not in that room. It's highly confidential, attorney-client privileged. Don't do that. Participation in procurement, we take state law purchasing requirements extremely seriously. So state law tells us exactly how we select our vendors, how we advertise our projects, and how we award our bids. We do not award bids outside that process. And so just to make sure that we hit this message all the way home, we tell city council they cannot participate in procurement. They can't call their buddy up and say, hey, take me to dinner for under $100 and I will get this contract approved for you. It doesn't work that way. If we find out that a council member is having a conversation with the vendor outside of the purchasing process, we disqualify that vendor and they cannot do business with the city. That is how serious we take this. And then campaign contributions. If you all decide you want to sit on that fabulous chair every other Tuesday evening and be a council member, just keep in mind when you get a campaign contribution, if they are suing the city, it cannot exceed, or you cannot accept any campaign contribution from someone who is suing the city for $5,000 or more, exclusive of attorney's fees. So you cannot buy yourself a settlement or a lawsuit. I went over that super fast because you're all very smart people and I know you're going to grasp it quickly. However, if you can't sleep tonight or if you really want to get in the nitty-gritty, you can read a copy of it in Chapter 2, Article 4 of the City Code of Ordinances on our website. If you happen to have questions, you can ask a written ethics opinion from me. Some people call this a get-out-of-jail-free card. If you give me the facts ahead of time, I will write you a legal opinion that says, Vice Chairman Jane, you have stated the facts as blah, blah, blah. Based on my understanding of how the Independent Ethics Review Board has looked at previous cases, they will find this is or is not a violation of the code. Now, if somebody comes up and says, Commissioner Jane, we know you did this, you'll say, I have a get-out-of-jail-free card from the city attorney. I'm in trouble and not you. You no longer have a violation. So I always suggest, if you have questions, ask ahead of time. It's so much cleaner for you, and it gives me an evening off. So if someone doesn't follow the rules, what happens? Well, as a resident and another board member, you can file a written complaint, once again, with the city clerk's office. They are basically the gatekeeper of all that is good and evil. So this written complaint must be signed and sworn. It must name the person who you believe has violated the code. It must be a violation that has occurred within the past year or within 1 year that you have found out of. And we're going to ask that you go ahead and state which violation it is. It's a lot easier for you to say, I believe this behavior is that, than for us to sit back and go, well, I wonder which of the 11 rules they violated. We may not see it the same as you, and we ask that you go ahead and put that on there. Now, as the board reviews it, they may find additional violations, but it's extremely helpful to them for you to point out at least the one that you think applies so that they can get the process started. So what happens is that once it's submitted to Ms. Linda, it is then sent to me. I confirm that it's signed and sworn, that the person is subject to the code, which is all, as you know, the players, and that the violation is in fact one of the violations listed. If you say so-and-so ran a stop sign, sorry, that's the PD's problem, not the ethics board. So once I've confirmed all that, it goes to the ethics board, I wash my hands, and a new attorney comes in. I'm conflicted out because I'm your attorney here. I cannot serve both sides. The Independent Ethics Review Board has 2 hearings. They do a first review, they look at it and go, yep, the city attorney got this right. It's within a year, the rules apply to this person, and then they say, well, if the facts as presented are true, it might be a violation. Then they go on and have a second hearing. It's a full-blown investigation, public hearing. They invite people, we give them snacks, and they go through the code and determine whether or not a violation has occurred. They also have the opportunity to negotiate a settlement while they're going through that. If the person says, you know what, you're right, I'm wrong, I didn't mean to make the mistake, they can go through and have a settlement and kind of get out of it without having the full-blown hearing. They do have an opportunity to issue sanctions for violations. These are our sanctions, starting at the top, letter of notification, basically a shake your finger, no, don't do that, all the way down to removal. So number 6, recommend removal of an appointed official. If you're voted in, you voted out. The board does not have the authority to unilaterally remove them. They also cannot unilaterally remove you, but they can recommend to city council that based on behavior and this violation, it is so egregious that a fine, letter censure, or written reprimand is not sufficient, and that you need to let somebody else take over your seat. So I went really super fast. Before we play the quick game, do you have any questions? Okay. And just so you know, oh, yes, sir.
Do we have to take the training from the Texas Attorney General's office?
For open meetings and open records, yes, sir. I'm not giving you that one, but I am going to get you off the hook for your ethics. So this counts for ethics, but yes, the online Attorney General open records and open meetings, you still need to take that.
Okay, that has to be done by the end of the year.
Linda? How long do they have to do their open meetings, open records with the AG? It was like 30 or 60 days.
It's 60 days.
60 days from the date you were sworn in.
Okay, thank you.
Okay. Any questions on ethics? Yes, sir?
So when is the swearing in? We
This-
have not been sworn in for this term.
Uh-oh.
Oh, sorry. We did one by one. Sorry, I take that back. Okay.
That wasn't even in the ethics presentation. Let's start over. Okay, there you go. Let's just get it done by New Year's and you'll have made the deadline. That'll be safe. All right, so since you don't seem to have any questions yet, we're gonna quickly play the game of ethics and let you all go home because as interesting as this is to me, probably not so much to you. So let's go through this. And just congratulations, you all did not make the cut. So this is if you serve on any other board, you all are not guilty parties this year. So to increase revenue and promote tourism within the city, we have a city council member who says, you know what? We need to have a kayak-friendly boat ramp over the Brazos River and Oyster Creek right there by Constellation Field. This is a moneymaker. So first question before you, does it matter that this particular council member's daughter owns a rent-by-the-hour inflatable kayak company? Is this a violation? This is participatory, please. Yes, it's a conflict of interest, special economic benefit within the first or the second and third degree. All right, good job. Always the supportive parent. The council member then makes a few phone calls, gets the boat ramp idea on the Parks Board, and gets positive feedback. This was not covered in your actual rules and regulations for the ethics, but this is still one of the moral codes. What is the concern here? Yes, sir, it's a conflict of interest. Additionally, the council member is using their position to get a privilege that is not open to the rest of the public. So the rest of the public can't just pick up the phone and say, get my stuff on that Parks Board now. And a council member can't either. That's why it's a violation. So we are so excited about this. Parks Board goes, yes, we need this. And you know what else we need? Food trucks. We want full people kayaking down Oyster Creek and the Brazos. What could go wrong, right? So they're all excited. So they suggest in a public meeting to add pad sites for the food trucks. So we've made it through the Parks Board. We're now sitting at P&Z. As the item is being presented, we have a P&Z member sitting up there, starts texting their spouse, honey, we're gonna hit the lottery. Buy that food truck. I know we were thinking about it, but this is it. Go buy that food truck. Do we have a violation? What is your violation here? Trick question. This is occurring in a public meeting. So anybody sitting at home with their popcorn watching the meeting, like they are right now watching you all, is getting that same information in real time. It is not confidential. Yes, it's a trick question. And don't feel bad, everybody's missed it so far. So obviously, we all think this boat ramp was great. So now our economic development corporations 4A and 4B want in on this. They're going to offer some incentives to make sure we get the very best kayak company in the city. But of course, the council member's daughter is the very best kayak company in the city because he sits on both these boards and he's talking his friends up. So they give him all the money they need to offer all costs to relocate her to the city of Sugar Lands. Do we have a violation? It's a continuing violation of? Excellent. Y'all are going to be great council members someday. So now that we have the financing secured, the Parks Board is endorsing it and zoning is in place, City Council then gets to vote on whether or not to grant a license. Of course, always a fun group that they are, they grant an exclusive license. And what action should that city council member take at this time to prevent a violation? Yes, I heard somebody say abstain. If I had like a gold star, I'd hand it to you right now. Yes, the council member would need to file a conflict of interest. I heard that over here. Abstain, and third requirement. There you go. Y'all are awesome. And if he didn't, it's a conflict of interest. Okay, so 6 months, things are going great. We are making money left and right. We cannot believe how great this is. Unfortunately, as we all know, full bellies, alligators don't mix. Labor Day weekend, we have a kayaker who got bit by the alligator. So now the injured kayaker has decided they're going to sue the kayak company. And of course, the deep pockets, the city. So as a result of this lawsuit, City Council has to go sit in the dining room and hear all about this litigation with me and talk about the lawsuit. What are our concerns at this point? Specifically with that council member, what do they need to do? Are they allowed back in that room with me to talk about the lawsuit, or do they have to abstain? The lawsuit, it's his daughter's company, and the lawsuit is against the daughter and the city. That's fine, we're here to have questions. So yes, he would need to abstain because he has a special economic benefit and a conflict. So City Council says, you know what, you're right, we should have thought this through. Food, alligators, kayaks, bad idea. And so they revoke the daughter's license and says, you know what, just back your boat up there, drop it in, paddle away, have fun, no food, it's on you. Bring your own picnic. So then we have a local resident who goes, you know what, I wouldn't have made those stupid mistakes. I would have made the food truck people there. I would have said, you gotta wait 30 minutes before you get in the boat. You know, we all learned this growing up, no swimming within 30 minutes of eating. And so he files a complaint with the Independent Ethics Review Board and says, I should have had an opportunity to compete for a license. So he's done that. So the Independent Ethics Review Board is now reviewing it. They are trying to decide whether that council member had a violation, which I believe you all believe is a conflict of interest, and whether or not they would have a problem with him with council issuing that gentleman, or not issuing that gentleman a license for exclusive operation of the kayak. So how this plays out after talking to the ethics board, because they are the ones that make the final decision, they tell me that had the council member abstained all along, they could have introduced the idea and then abstained from that point forward, they would not have found a violation. Because they brought the idea forward, said, hey, my daughter thinks this, because council members are allowed to come up with ideas and present them. But if they had that special economic benefit, then they now have to subtract themselves from the process. He could not have made the phone calls to the Parks Board, hit the P&Z meeting, any of that stuff. Had the council member done that, there would have been no violation, and there would not have been a problem with that individual who also wanted to be considered for that. However, our council member, as you know from the examples, kept playing all along, dutiful parent, loves his child, and did not abstain and participated fully. So I asked them, what do you think a violation or a sanction would be for this? And they said at least a $2,000 fine, and they probably would recommend a recall because it is so egregious that you can't do that sort of thing. So congratulations, you're done with me for a year. I appreciate your participation. And I look forward to teaching you ethics next time. Do you have any questions for me? Well, thank y'all very much.
So do I, hearing a motion to adjourn the meeting?
I'm Lana Goldberg, and I move to adjourn the meeting.
Have a second? State the name, please.
I am Mumtaz Qureshi, I second the meeting.
Please vote at this time. Those in favor of adjourning? Unanimous vote. At this time, December 10, 2025, Building Standards Commission meeting is adjourned. Thank you very much.
Thank you very much.
Jumping at the opportunity.